ladies and gentlemen. Thanks for joining us today again. Welcome to the program Israel on Trial, which follows the outline of the book written by Dr. Mati Dubois and Dr. Teker. This is the fifth and the last for this year's session of our leadership training seminar, organized by Elnet and Thinc, dedicated to all the people and organizations which advocate for Israel. A panel of experts will give short presentation, which will be followed by Q&A and discussion. The topic of our seminar today is a new approach. We will speak of Israel, the Middle East, and the future of international criminal law, the Middle East and the ending of wars, the implications of the Abraham Accords for resolution of the Israel-Palestine conflict. Andrew Tucker from Thinc will be the moderator, and the speakers will be Yael, Gvirsman, Radzyner Law School, Dr. Daphné Richemond-Barak from IDC Herzliya, Ambassador Daniel Taub, Hanadiv from Jerusalem. Andrew, the floor is yours.
Thank you so much, Ariel. Well, good afternoon, everybody. Good to see you all from many different countries, as far away as Singapore and probably further, several European cities I can see, and of course, Israel as well, perhaps even the United States. We're not a big group, but we're a dedicated group. So thank you for those of you who have participated for these 5 sessions. And even if you haven't, welcome to this final one. In this course, we've been exploring actually what is international law. And does it have a positive role in the resolution of the conflict, or is international law, or the use and misuse of international law, perhaps an obstacle to achieving peace in this conflict? So we started out with a session talking about international law. We've looked at the different UN agencies. Last week, we talked about the issue of apartheid. We spoke about the UN Human Rights Council and how one-sided in many ways the UN system is stacked up against Israel. And in this final session, we have 3 amazing people who are going to explore with us to think about, well, what is a way forward? What is the way forward for Israel, for the Palestinians, for other actors in the conflict? What can we learn from the lessons of the last couple of decades? And also, I think equally interesting is what are the consequences of the way law is used in relation to this conflict for other conflicts in the region? And we have many conflicts in, just thinking of the Middle East itself, let alone other regions of the world. Now, before I move on to our first speaker, who will be Dr. Daphné Richemond-Barak, the first thing we have to do, obviously, when we talk about international law, every lawyer knows that the first thing you do is to decide what is the issue or the conflict or the problem that you're trying to solve. It really begins with framing the factual issues that you're trying to address. And I think this is one of the problems here, is that we have a very multi-layered, multifaceted conflict. In fact, you could say there are different conflicts going on simultaneously. Some people see it as a territorial conflict between Israel and Palestinians, or Jews and Palestinians, who have competing claims to territory. There are many on the Palestinian side who see this not as a territorial issue, but one of fundamental justice. They think the creation of the State of Israel was a mistake. It was a breach of the League of Nations covenant, which intended a system for independence for the peoples of the region. And 100 years ago, the Jews were not in the minority. It was the Palestinians. That's their narrative. We saw that in the ICC proceedings, very much strongly argued. So that's really a justice, human rights, self-determination kind of approach. But we also have military conflict. We have an international armed conflict between Israel and a number of non-state actors, which invokes international humanitarian law and the law of war, which Daphné will speak particularly about. Well, we also have an international conflict Israel is not only engaged with non-state actors, but there are state actors. As far as I understand it, Israel is still technically in a situation of war with Syria. That conflict has never been finally resolved after the Yom Kippur War, arguably. Interested on your views, Daphné, on that. When does that war come to an end? So law comes into play in many, many different contexts, and all actors are using law and legal systems to advance their case, as they're entitled to do. The EU, for example, European Union, uses law to justify its two-state policy. We saw that in our first session. The EU has the view that everything outside the Green Line belongs to the Palestinians. It's to become a Palestinian state, and it invests billions of euros in creating that state. That's based on a legal analysis. We've seen at the Human Rights Council, which based on international human rights law, has now an ongoing permanent commission inquiry into the situation in the Palestinian territories. We have, of course, the Wall advisory opinion of the International Court of Justice in 2004, which was about the Wall and its status under international humanitarian law. And of course, not least, we have the International Criminal Court now, which is all about the Rome Statute and international criminal law, which is another area of law altogether, similar but different from humanitarian and human rights law. So we have many different legal regimes and many different conflicts, and different actors using different legal regimes to argue their case at all those different levels. So we're going to open the floor in a sense to, I think, just explore a bit this evening where all of this has taken us, what some of the lessons are. And if we think about the role of international law, which at least formally speaking is intended to play a role in the peaceful settlement of disputes. And if I quote from Article 1 of the UN Charter, the purpose of the UN is to maintain international peace and security, take effective measures for the suppression of acts of aggression, and to bring about by peaceful means, in conformity with principles of justice and international law, the adjustment or settlement of international disputes or situations which might lead to a breach of the peace. That's the UN Charter, Article 1. So law has a role in promoting peace and security. Now I'd like to ask Daphné, Dr. Daphné Richemond-Barak at Richemond University, formerly IDC Herzliya, in Herzliya. She's absolute miracle in, I don't know how you managed to do all the things you're doing, Daphné. You've just produced or had your latest book published. It's the new edition of Roseanne's book on the World Court. Going to be a fascinating read. I haven't had the opportunity yet to read it. You've written a book about underground warfare, and you've launched a project called End of War. So I wonder if you might share with us some thoughts from your perspective of, I guess, principally international humanitarian law, the law of war. What have we learned from all of this? And is there anything that you've learned out of your project of thinking about how we bring wars to an end, how we know when wars have come to an end, and what role law can play in all of this? Share with us whatever thoughts you might have. Thank you, Daphné.
Thank you very much, Andrew, and thank you very much, ELNet and thinc, two organizations that I deeply admire for putting this together, and to my fellow panelists, distinguished panelists. I'm very happy to be here. I want to address the End of War project, which I co-founded with Professor Laurie Blank from Emory Law School, in just a little bit. But just before I get there, with your permission, Andrew, I want to take on the main topic of today's discussion, which is a new approach, a way forward. So can we think about the role of international law or the role that Israel could play in the international legal realm, which includes, of course, international norms and international institutions and mechanisms? What should that new approach, what could it look like? What should it look like? And then within that, I hope to address as well the questions on the End of War project, if that's okay. Would that be okay with you?
Perfect, perfect.
Okay, great. So, so the elements of a new approach, or how I would think about this question, which, by the way, is a very provocative question and such an important one. And I'm really, again, glad that you're putting it on the table for us to reflect on. I think this new approach could have a first component, which would be protecting the integrity of international institutions and international mechanisms and international norms. Okay, so protecting the integrity of what we actually have. And here I saw in the chat actually a comment by Hans-Peter on people who are referring to the modern international law. And Hans-Peter, you could not have provided me with a better trampoline to discuss this matter, right? There is no such thing as modern international law. The new approach should actually reinforce the value of traditional international law, of the core principles of the UN Charter, starting, by the way, with Article 1 that Andrew just read for us. So I think this protection of the international liberal order, if you wish, is critical and should be part and parcel of this new approach. So let me give you a few examples. In 2011, Palestine made a membership request at UNESCO to become a member of UNESCO. This was before Palestine achieved its new status in 2012. And we're talking here about a UN agency, which, that focuses traditionally, again, on education, arts, sciences, and culture. And clearly, Palestine's attempt at becoming a member in this specialized agency of the United Nations was a way to circumvent the charter-based membership process, the way in which a new state becomes a member of the United Nations. This was meant to achieve a political gain, and it had actually very little to do with UNESCO, with science, with culture, and with education. And so when attempts like these are put forward, right, and there are other examples, but I'm just using this to illustrate the point, they actually undermined what I call the integrity of international institutions and international mechanisms. They should be condemned. They should be called out for what they are. There is no modern international law. These are agencies that have a mandate, that are there for a purpose. They are not meant to be used for by whatever entities in order to achieve their political goals. So I think this is the kind of instances, and here I'm using an example with Palestine, but I'm sure there are others where Israel could come and be an advocate for international law as it is and for the integrity of its norms and its mechanisms. Let's talk about maybe other examples. The International Court of Justice, which again is the temple of state sovereignty, right? It's a mechanism that was built for states, by the way. And here we're seeing some attempts at undermining the mechanism, which was designed to resolve, again, state-to-state dispute. So these mechanisms that are undermining the integrity should be signaled, should be explained as such. Meaning you can come up with very convoluted legal explanation and theories why maybe Palestine's case at the International Court of Justice the court should not exercise jurisdiction. But maybe we should also just make the very simple point that this is not what the court is meant to be handling, right? And I know some of us try to make this point before the International Criminal Court. It doesn't always succeed, but I just think that the regular and recurring calling out of these attempts at undermining the integrity of institutions is something that is very important. And again, we should insist on and remind the international community of what was the original purpose for which these mechanisms or norms were intended. And here Israel can position itself as part of this new approach as a guardian of the existing post-World War II normative order, something which, by the way, other states might find equally interesting and valuable and might, join the bandwagon here. So I would really insist that this is important. And we know, by the way, that when international law gets reinterpreted or mechanisms get used in a certain way again and again, and the practice is recurrent, then of course that modifies international law. This is why people, and Hans-Peter pointed that out, mention now the modern international law or the new meaning of the concept of proportionality. Let's make sure that we call out the attempts at modifying things that are, you know, the underpinnings of the international legal system, both norms and mechanisms. So that's my first point. My second point as part of this new approach would be the following. I think that Israel in general, when it comes to international law and international legal and political fora, should stop settling for small wins. Let me explain what I mean. Very often, our amazing diplomats and legal advisors, they work tirelessly, and I'm sure Ambassador Taub can attest to that, to make sure that whenever there's a decision that is being adopted, then there will be a dissent. Maybe we won't win the majority, but maybe Israel can influence and get a dissent. Maybe there's a General Assembly vote. Israel could work, again, tirelessly in the hallways of the United Nations headquarters in order to get a few more abstentions. Maybe Israel can work again to get an empty seat at a time of a critical resolution being voted. And these are sometimes the product of months of work to achieve diplomatic and legal wins. And they are, and I don't want to undermine them, that's not my point. I'm saying that they are important, but oftentimes the entire attention and all the resources are focused towards those wins that are important, but yet do not dramatically change the picture. And I think Israel's new approach to international law should be one that actually seeks to achieve big wins. And of course, now that begs the question, right? What is a big win? What would Israel like its relationship with UN institutions, with specialized agencies, with international court and tribunals? What would it want it to look like in 10 or 15 years? So, of course, the big challenge with these big wins, right, is that you need to know what they are. So, I can extrapolate a bit and try to think about what that would mean. I know Israel has been trying, again, working to get a seat at the United Nations Security Council. This has not worked out for a million reasons. This is something that I think could be a big win. It could be a strategy that is a 10-year plan in order to get Israel to have a seat as a non-permanent member, of the United Nations Security Council. There are other examples that I can come up with, but basically the main question that I want to ask you, right, is what would a big win look like from the perspective of Israel in the realm of international law? Maybe an offshoot of that would be asking the question, which I'm going to address a little bit later. What's the 5-year plan? And I'm going down, in my expectations in terms of the timing, but what's the 5-year plan for changing the dynamics at the UN in the wake of the Abraham Accords, right? So there's almost no discussion of that. I hope there's some discussion, again, within the Israeli government and diplomats and at the UN mission, Israeli mission at the UN, but this requires a strategy, right? Where do we want to be in 5 years or in 10 years? So I want to ask you this question, this 10-year international law strategy, we need to shape it. The new approach must find an answer to this question. And of course, as part of this effort, it should also emphasize the opportunities that face Israel in this new Middle East, right, in the post-Abraham Accords Middle East, not just the challenges ahead. That's a side point, but I think that's also part of what we would call this new approach. So my first point and my second point, and I get to my third point. So is there a role for international law to play in bringing the Israeli-Palestinian conflict to an end? And here I tackle more hands-on the question that Andrew asked me at the beginning. This is a very good question because, again, as some of us are international lawyers, we want to understand how to use the tool that we know best in order to achieve what we seek to achieve. And again, bringing the Israeli-Palestinian conflict to an end is definitely something that I think most of us would like to achieve. So let's think about the role of international law here in the process. So international law is designed to prevent and limit conflict. This is the big insight of again, after the Second World War, the Holocaust, the atrocities, and also to some extent, the trauma of the First World War. International law decides at its prohibited, states are prohibited from using force. This is actually states agreeing to and putting forth this prohibition. And then there's the creation of many mechanisms for the peaceful settlement of international disputes. In addition to that, so the prevention of conflict and also the creation of mechanisms for the peaceful settlement of international disputes, international law also develops what we call the laws of war, the law of armed conflict, international humanitarian law. That is the regulation of war while it is ongoing, right? The regulation of armed conflict. So many aspects that touch onto war, whether it's prevention or the resolution of disputes or the regulation of war itself, international has a lot to offer, or it has a strong nexus to conflict and peace and security, which of course is the core of the UN. But, and I think this is important to state it as it is, international has little to offer when it comes to bringing wars to an end once they have begun, or even identifying what the end of war looks like. So let's think about this for a second. What would the end of the Israeli-Palestinian conflict look like? Do we even know? So you were asking before, Andrew, about Syria. So I believe actually that Syria, there was an agreement, I think it's called the disengagement agreement, that was signed between Syria and Israel after the Yom Kippur War in 1974. So technically, formally, this war has actually ended if we take as axiomatic that war ends whenever some kind of settlement is reached. But again, we know that has been actions taken by Israel in Syria, and so does that mean that this has rekindled the conflict? This is a big question of international law, but most, I think, would agree now that the law of war does not apply between Israel and Syria. But I'll leave that aside for a second. And I want to challenge this question a bit more and deepen it a little bit more. So what would the end of the Israeli-Palestinian conflict look like? I want to tell you that just a few days ago, I was in the UAE, and I visited the Palestine Pavilion at the Expo 2020 in Dubai. So if you know about this, Expo 2020 is actually divided in different pavilions, put and designed and shaped and presented by different states. So Palestine has a pavilion, and I went to visit it. And of course, it's a very, very interesting visit, as you can imagine. But most importantly, for our purposes, it shows a map of Palestine, which covers all of Israeli territory, including Masada, Haifa, and more. So what does that mean? Why am I bringing this up here now? Because if you think about what the end of the Israeli-Palestinian conflict looks like for Palestine, apparently, it means that all of Israel becomes Palestine. If you ask Israel what the end of the Israeli-Palestinian conflict look like, by the way, if you were to ask former Prime Minister Benjamin Netanyahu, we might say that it would look like a 20-year truce, a 20-year status quo where there is no war. Maybe for him, that would mean the end of the Israeli-Palestinian conflict. If you ask an international lawyer, they might tell you something else. The bottom line is that we don't even know, we can't even agree as to what the end of the conflict looks like. Does it mean that there's no hostilities at all, which would be, I guess, the view preferred by former Prime Minister Netanyahu? Or does it, international law also looks at it like this, by the way, and I'm going to get to that in a second. But so we have a problem identifying what the end of conflict looks like, and we tend to expect international law to give answers to questions, whether it is what the end of the conflict looks like, or maybe even just being capable of ending this conflict. Can international really end this conflict? Well, I want to suggest that international law, whether as a set of norms here, I'm talking about the norms, not the mechanism, is not well equipped to put an end to a conflict, to put an end to this conflict, or even tell us when the conflict has ended. So if we look at what the law says, it has a different take on international armed conflict versus non-international armed conflict. International armed conflict between states, vaguely the law, the Geneva Convention said that they would cease when there's no longer any hostilities, active hostilities, or when the military operations have closed. But again, does that mean, so when the last shot has been fired is when the conflict ends? I'm not sure that this would be today the general accepted opinion. If we look at non-international armed conflict, which would be a conflict between state and non-state actors, then it's even more confusing, and the law is even less clear. There's really not any rule or guidance to identify the end of the conflict. Again, we can learn from international armed conflict and think that maybe if the last shot has been fired, if there's no longer any active hostility, if maybe one of the parties to the conflict ceases to exist, that maybe might signal us that the conflict has ended. So what I want to say is that the law really doesn't tell us when the conflict ends, and we need again to ask ourselves, what would it mean for us for the Israeli-Palestinian conflict to end? Does it mean the creation and the establishment of a Palestinian state alongside the state of Israel, for example? That could be a valid definition, but it's not a legal definition, is what I'm trying to say. And by the way, international law also does not set out rules for how parties to a conflict or imposing to the parties to a conflict to end the conflict. So it doesn't tell them how to end it or even impose an obligation to end it. So what does this mean? It means that when we look at international law as the sole provider of a solution here, it doesn't have it. It doesn't have it in the jus ad bellum, which regulates the entry into war. And to be honest, to put that stress on the law of war, to transform the law of war from a regulatory regime to a framework with a new mission, which would be to end an ongoing conflict, I think that's really going too far. And it's a step that I think actually would hurt the legitimacy of the rules, and that we don't want to get there. So let's not expect too much of international law here. And that's, in a sense, some of the issues that the End of War project that we were talking about before seeks to examine. Let me get towards, work towards my concluding remarks here. What would have a better effect, right? Because I don't want to end on a negative note, right? So international can do it. So what are the alternative approaches here? So I think the Abraham Accords, and I know Ambassador Taub will speak more to this later, but I just want to say a little bit about it. This is a more, this could be a good channel to try to actually solve the conflict. And it is connected to international law, of course, because these accords are products of international law. But this is a more direct, these accords have created a more direct channel of communication with between Arab states, some of them, and the state of Israel. These Arab states are now in a position to influence Israel. We can expect that in a not too distant future, the Abraham Accord states, whether it's Bahrain or the UAE or Morocco or Sudan, will want to engage with Israel or engage Israel on the Palestinian question. At some point, it's going to happen. It might involve the right of return. It might involve issues that are very, very sensitive. Right of return, East Jerusalem, maybe a potential future annexation plan, which they would certainly oppose. Israel needs to be prepared for that. This will come. So the new approach needs to channel these Abraham Accords to actually anticipate international legal questions that are going to come up. Let me highlight a few additional ideas. The UAE has just been elected to serve as a non-permanent member of the United Nations Security Council. That's a very interesting development. What does that mean for Israel? Has anyone thought about this? Is this part of our strategy? The new government, right? It's not so new anymore, but still, we always, I think we'll call it the new government of Naftali Bennett, our prime minister, hasn't said much about these Abraham Accords. It needs to strengthen the accords. It needs to show that he is equally committed than his predecessor to these accords. And I know that our partners in the UAE, Bahrain, and Morocco are anxiously waiting for signs of this. So Israel needs to anticipate and channel the energies of the Abraham Accord and their impact in international fora and on the peace process, both of them. And just to sum up, because I think I've used all my time, the points that I brought up are the following. Israel needs to position itself as a guardian of international law and international mechanisms. This is an active, proactive role that I'm suggesting here for Israel. And it can happen alongside Israel's existing role that Israel has taken in a very smart way, I think, to be involved and to be a leader on global challenges such as climate change. Now, the second advice or the second wave or component that I set to this new approach would be to go for the big win. Define what a big win means, what it might be. Let Israel set medium-term goals and work to achieve these goals at the ICJ, at the ICC, at UNESCO, by the way, where there are unprecedented opportunities and leadership there. Then Israel could take an active role as well as part of this new approach in translating the Abraham Accords in international law terms at the UN again, at the United Nations Security Council, on working to change voting patterns among Arab countries, and on taking the example of the Human Rights Council, by the way, amazing example where there was this joint declaration on women and peace and security that was signed by Abraham Accords countries and Israel and many, many other states. That was a remarkable development. And I think this could fall under a big win under what I'm saying right now. And finally, I think, and this is critical as we can contemplate, a resolution to this conflict. there needs to be an understanding that the role of international law to end the conflict is limited. It's mostly a political process. We can't expect international law to achieve the impossible, and we need to recognize it for what it is and use it for what it can achieve. And it can do a lot, but it can't do everything. This is something that I also tend to tell my students, by the way. International cannot do everything. So thank you very much, and look forward to the discussion.
Unmute myself. Thank you so much, Daphné. You've just written a book. You've just prepared Shabtai Rosen's book on the World Court, the ICJ, and you spoke about the integrity of the institutions. How damaging do you think, or how problematic do you think the Wall advisory opinion was and has been? I think, for example, the court said in the course of that opinion, Israeli settlements are illegal. And it's become a mantra for people to say that any Israelis living or existing outside the Green Line are ipso facto illegal because of that opinion. Now, most of us would understand that, obviously, Article 49.6 of the Geneva Convention prohibits certain activities, but it doesn't mean that every Israeli Jew or Arab living outside the Green Line has suddenly become illegal. So that's an example of a judicial determination. It's an opinion. It's not binding, but it's out there. How do you rectify that? How do you reassert the integrity of the court if 20 years down the line?
Look, this is a big question, Andrew, but I definitely think that the advisory opinion was a turning point. It was a turning point not only in the legal strategy of the Palestinians, but it was also a turning point in Israel's approach to international courts and tribunals. And following that, there was the Goldstone report, and Israel put in place a lot of measures following that. So I do think that it's a critical moment, and it's been built on, and we are likely to continue seeing the effects. So I agree that this needs to be part of how we look at the progression and the evolution and anticipate what will the next thing be.
Yeah. Okay. Thanks, Daphné. Well, stick around for the Q&A if you would, because I'm sure you'll get lots of questions and feedback. I'd like to turn to Yael Gvirsman, who teaches international law at Richemond University in Herzliya. She's an advisor on international humanitarian law, international criminal law. She was an author of submissions to the International Criminal Court in the recent proceedings in relation to the situation in Palestine. She consults organizations around the world on these and similar issues. Yael, welcome, and thanks for joining us. Good to have you. And I'd love to chat with you about the International Criminal Court. Everybody's looking to the criminal court to bring justice, aren't they, in relation to this conflict. The court has accepted that it has territorial jurisdiction in relation to Israeli activities in the West Bank, Gaza, including East Jerusalem. This could even extend to prosecution for apartheid, potentially under the Rome Statute. So it's a big one. Do you think the ICC is playing or can play a positive role in solving this conflict?
Thank you, Andrew, for this question. First, thank you very much to Elnet for this invitation, for Peter and Sarah and Andrew for putting all of this together, and thank you for all of you for being here this evening. I was so hyped about this talk, and now I've listened to Daphné, and I'm just still contemplating, the end of war. So I'll have to, shift back to the ICC. Okay, so very important question. What is the role of the ICC in the Israeli-Palestinian conflict? A few introductory words first about the framework of this course and how this sort of my intervention comes in. In the introduction to the course, you highlight that the course will deal with international law and how the legal system works, the misuse and manipulation and the mitigation of threats and maybe even opportunities facing Israel. And finally, what is the role of international law, specifically the ICC and other international criminal law mechanisms in what is called protracted conflicts, or conflicts that are intergenerational. We have whole generations that are born into conflict. And so how can we, the role of international law, international adjudication in historical justice, in affecting the narratives. You highlighted the 2004 ICJ advisory opinion and how that shaped narratives. And I'd like to piggyback what you said, Andrew, about mantras. So a lot of what is done in this field, in the field of international law, adjudication and the decisions of international UN treaty bodies, committees, and other more adjudicative bodies, is that any sort of decision or condemnation that is perceived as a win for let's say the Palestinian side, even though I'm not really sure what the Palestinian side is and what could be a win for let's say the Palestinian population, is then taken and becomes a mantra. And whatever nuances and let's say sort of hesitancies that we can highlight, or problems we can highlight whether in process or in the substance of these decisions, sort of fades away after time when they are re-embraced by public discourse and become mantras. So we have sort of this flattening of international law instead of really looking into the in-depth of questions. And of course, that's a bit natural because not everyone, thankfully, is a lawyer. And also law by essence uses terminology and is as professional as possible. It's sort of like a guild. It uses its own terminology also to sort of self-justify itself. So yes, the mantras. And the ICC decision, the pre-trial chamber decision in the ICC in the Palestine situation, is the fact that jurisdiction has been recognized, at least for this very, very initial sort of pre-trial stage, has already become a mantra, of course, and it's being celebrated as a big win on the other side. Just before jumping into the topic, I'd like to say I see Hans-Peter, among others, and also speaking about if nations would recognize the rights given to the Jews in 1917, 1920, 1921, 22, they all deny them. I would really like to take international law as an opportunity. International law recognizes the state of Israel. The state of Israel exists by its declaration of independence and by the acts on the ground of people on the ground who became Israelis, and also of Israeli leadership, but also, and not less importantly so, by recognition of the United Nations. So international law recognizes the state of Israel, and whoever questions the existence of the state of Israel simply does not abide by international law. I think that should be the beginning of any lecture in international law that has to do with the Israeli-Palestinian conflict. There is a very big difference between human rights discourse that is a legal discourse, as opposed to human rights discourse that has to do with advocacy, and therefore is more political and more wants to change law or whatever, as opposed to what law is. Daphné said we should begin by protecting and defending what law is. So we have major wins already in international law and universal values, and we should abide by them. This all links me, first of all, to the ICC jurisdiction decision. So before saying if it has a role there, I mean, let's cut the, to cut the story short, not, I would say the ICC is no panacea for the Israeli-Palestinian conflict, but I'd like to say a few words about why. Also in view that, the International Criminal Court abides by international criminal law. It has means that are criminal law means, the general principles of criminal law, and it is also limited in jurisdiction to specific crimes. After that, it has criminal procedure, the truth outside the court. It is limited to the truth that a court can provide. And if we have sort of the Jewish thoughts, classic traditional Jewish thoughts, we have this adage saying that without truth there is no justice, and without justice there is no peace. But to expect from the ICC, the International Criminal Court, to provide peace is a very far-reaching expectation. We can expect from the ICC to abide by its own rules and by its own mandate. So this mandate was achieved through consultation of states, through deliberations at Rome, at the Rome Conference. And actually, not only that, it has been achieved by a process of at least 200 years of international law. So from the end of the 19th century, with Gustave Mounier's idea of establishing an international criminal court for the Geneva Conventions, until the International Criminal Court that we know today, 200 years have gone by, at least 12 attempts to establish an International Criminal Court, and all failed. And most of them failed on the question of jurisdiction, on agreeing of what jurisdiction this International Criminal Court should have. The agreement in Rome is that the International Criminal Court is not a court of universal jurisdiction, meaning that it has a global reach anywhere on the globe where international crimes are committed or allegedly committed. It has strict conditions for its jurisdiction. So this is the compromise that was reached in Rome. And this is where, to jump on your first session with Professor Dov Jacobs, the politics came in. Okay, this is the role of politics in shaping international law. But the minute this rule was achieved, that's where the politics, it stops at the door and the law begins. And this is where there, as lawyers, in the International Criminal Court is made of the legal profession, either the judges, the prosecution, the defense, or the representative of victims. They are all from the legal professions. They're not diplomats, they are not politicians, and therefore their role should be strictly abiding and implementing the law of the Rome Conference, of the Rome Statute. So the decision, I don't want to go too much into the decision. I'll just say that my amicus curiae that I submitted was against the jurisdiction of the International Criminal Court in the Palestine situation, based on the principle of legality in criminal law that calls for a strict interpretation of the law as opposed to a broad interpretation of the law. To jump on to sort of connect what you heard from Dov Jacobs, because I scrolled through the program and he was the one speaking about International Criminal Court. He named a few examples where the ICC expanded or broadened its jurisdiction, whether it was Burundi or Myanmar or Bangladesh, and maybe another case. I'll say that these are good examples, but at least in order to deviate and to cut off from the very mistaken narrative of the ICC as being anti-Semite. It is not anti-Semite. It is an international criminal court that has its own rules, and you have to have a broader vision than just our little world, talking about Israel and Palestine. You have to compare with other cases. But the cases that Dov rightly names, where ICC jurisdiction has to do with states that have not consented to ICC jurisdiction, and this is true for Russia in Ukraine and for the US in Afghanistan, for UN Security Council jurisdictions that were triggered in Sudan and in Libya. So this is really true. It's an existing situation. But in all of these cases, except for the Israel Palestine case, this was an expansion of existing law. So this was law that parties agreed to in the Rome Statute, that is hard law. For example, the Myanmar case. The Myanmar case deals with the genocide against the Rohingya, a Muslim minority that has fled, and ethnic cleansing, that it's Rohingya who fled to Bangladesh. And the question was whether the ICC has jurisdiction in Bangladesh. The answer was ICC has jurisdiction, seeing that Bangladesh is a state party and parts of the crime were committed on a territory under the ICC jurisdiction, and therefore crime, the parts of the crime, the elements of the crime committed outside this territory are also under its jurisdiction. So it did not redefine jurisdiction, it did not redefine the crime of genocide or of ethnic cleansing. In the case of the ICC in the Palestine situation, there is a redefinition of what jurisdiction is, because jurisdiction can only be acquired for the ICC by a state. And I will refer you to the reading material for the rest, the reading material for session 5. You can read my amicus curiae dealing with jurisdiction under the ICC. You can read Buchwald and Rapp, Stephen Rapp's, just one second, amicus curiae, a very important amicus curiae, Buchwald and Rapp, talking about the UN Secretary General Rome Treaty depositary and the acceptance of the Palestinians as a state party to the Rome Statute having no effect on the legal question of statehood or jurisdiction at the ICC. You also have in your reading material the Badinter, Kotler, Crane, and others amicus curiae on why Palestine is not a state. And finally, Benvenisti's, Professor Yael Benvenisti's amicus curiae on territorial jurisdiction of ICC in Palestine, why the court cannot make a determination at this point, seeing that the Palestinian people have not made a determination and the Palestinian people avoid making a determination. So really what we have here, in the Israel, in the Palestine situation at the ICC, we have the ICC in the eye of the storm of the Israeli-Palestinian conflict, because if, enough to look at the Oslo Accords and what the parties have agreed to be the crux, the most difficult questions. We have statehood, Palestinian statehood, we have territory. Territory, of course, affects Jerusalem, of course, affects settlements that you mentioned just earlier. And this only underscores why the ICC jurisdiction in Palestine, it really underlines how the ICC cannot really deal with this case without dealing with the conflict, which is not, it doesn't have the tools to do so. So what does it have the tools to do? There are legal questions, the gravest international crimes known to mankind. On these questions, the questions will be, legal. They will be demand from the parties to provide evidence, criminal evidence, not to talk about the politics, etc. And in my reading, they will give no or little hope for victims in view of justice, except for those atrocities that I don't know if they really fit in with the human rights advocacy discourse of Hamas deliberately targeting civilian population as a crime against humanity, the Palestinian Authority and torture, arbitrary detention of its own people, and so forth and so forth. So I'm not sure it will really achieve anything on that plan, on the human rights discourse. Of course, there's the settlements. That's another issue and a topic for a whole different session if needed, but we don't have enough time to delve into that. On the political term, on the conflict term, the ICC will only bring to a zero end game of the parties sort of trying, vanquishing each other. Are we at 0-0 all, or 1-0, 1-1, 2-1? And at the end of the game, no one wins. And of course, the victims are the losers in this issue. So to sum up, right? You are on.
Yeah. So Yael, we just turn to the last few minutes that we have. I know you've been thinking about the concept of
transitional justice.
Sorry, I almost said transnational. Transitional justice, and you've been thinking about, an alternative to the human rights paradigm in a sense, which is all about oppressors and victims. But there's another way of looking at it, of perhaps bringing a compromise between competing narratives. Could you share just a little bit about that and how you think it might potentially apply?
Yes, Andrew, thank you. Very briefly, because I don't want to go much over time, and Daniel still, we also have questions. So transitional justice takes a completely different viewpoint than international criminal law. First of all, transitional justice encompasses and englobes international criminal law and criminal accountability for whatever is crimes. But instead of leading to a zero-end game, it has to do with an agreement of the parties. Transitional justice, its very brief definition, is how to deal with past wrongs with a forward-looking approach. So the key here is forward-looking approach, as opposed to blame of one side over the other, or sort of a monopoly of wrong or rights. We, especially in a protracted intergenerational conflict as the Israeli-Palestinian conflict, we need a space where multiple narratives can coexist, same as the peoples need to coexist, and possibly two states, not legally, but possibly if that is the will of the people. The thing is, for transitional justice as well, we also need two to tango, and it's not certain that we have the will in leaderships either in Israel or in Palestine for this, or maybe partially in each of the places, which is not enough. I chose a case study of Sheikh Jarrah for possibly a model of transitional justice, and in the absence of sort of two to tango, then maybe the state jumping in the name of historical justice. I don't know if I have maybe 2 minutes to present the case, Andrew. You
2 minutes. Sorry, I'd love you to have longer, but that's about all we have, I think, Yael. Yeah.
Sure. So what does, we've heard about Sheikh Jarrah in the last military operations, and Hamas is sort of kidnapping or hijacking the Sheikh Jarrah situation, which is also a legal situation, an individual and collective question of justice or injustice. Hamas jumping in and taking that as if it were could be any justification to commit crimes against humanity of a deliberate attack against the civilian population. It cannot, in any case. But the situation of Sheikh Jarrah really has to do with Sheikh Jarrah is a neighborhood in Jerusalem. It was developed in the beginning of the end of the 19th century as one of the first neighborhoods outside of the old city at the time. It used to be for the wealthy Arab residents of Jerusalem built beautiful homes there. And there were also two Jewish neighborhoods in Sheikh Jarrah. Now, before 1948, there was no expropriation of property, at least not collectively, neither from the Jewish nor from the Arab population in Palestine. After 1948, Jordan takes control or takes effective control of Sheikh Jarrah in May 1948, and it declares the property that belonged to Jewish private property, it declares it as enemy property. So it declares a Jordanian custodian of enemy property. Also here, custodian enemy property is not exclusive for the Israeli-Palestinian conflict. We had, just for a few examples, we have these examples in Bangladesh, Canada, India, the United States in World War I and World War II. And Jordani there was a situation of refugees, Palestinian refugees in Jordan. It had to find a solution. Jordan and UNRWA built housing for the Palestinian refugees. And they also allowed them to live in let's say, we'll call them Jewish homes if just because short of time. The same thing happened on the other side. So Israel also took property that was called enemy property. And it also enacted the Israel absentee property law. This also has to do with the narrative of apartheid. So maybe we can come back to that in the questions. These are laws, including emergency laws between 1950 and 1973. They include compensation. And the idea was there are about 800,000 Jewish refugees in Israel that have to be settled. There are even from Iraq and Egypt in the 50s. Before that, Jewish refugees from Europe fleeing, of course, what we know, Nazi regime and so forth. And there had to be, there was a need for some kind of historical justice. These houses, many of them belong to Palestinians, maybe 300 villages, empty villages, had to be housed, as opposed to having people sleep in the cold and die of, it made no sense. And so people were housed there. I'll say on a personal note, my grandparents in 1948 were housed in one of these homes in Tzfat. And so, everyone is affected really. And the issue here now is the case of a Jewish property owner sort of asking the courts to give him the right to an access and an enjoyment of his private property. I'll say in just one sentence, in the name of historical justice, the state of Israel, my view is the state of Israel has to intervene so that this situation is not allowed, so that the people living in these houses right now should stay in these houses, if only for the reasons of reciprocity and equality of the law, in the same way that Palestinian residents, Arab Israelis, cannot come to the land or private property that was theirs, and they cannot evict the Jewish families that have been living there for 70 years. This should also be done for the other side in the name of historical justice.
Thank you, Yael.
Thank you.
Question. Yeah, great. Well, we'll come back to it. But I think what you just very much in brief indicating as well is you have a private property dispute, but you could bring in principles of equity or transitional justice, whatever you want to call it, looking at a broader level that sometimes need to override perhaps technical private law, public law rights and obligations. Big issue where I wish we could explore a bit more. I'm going to have to turn to you, Daniel, and I know you're under a bit of time pressures. Thank you for your patience. But just to introduce you to those who don't know you, Daniel Taub, ambassador to the United Kingdom. Well, it's 10 years ago, Daniel, I think that you were appointed, right? Before that, diplomat, legal advisor within the Ministry of Foreign Affairs, long experience in negotiations and many, many, many other things. Daniel, just from your long experience, okay, maybe with a legal hat on, but maybe your diplomat's hat on as well. What's going on with these Abraham Accords? 4 agreements between Israel, the United Arab Emirates, Bahrain, Sudan and Morocco. They kind of came out of nowhere, it seemed. These, I think the last 6 months of the Trump administration, when just after Netanyahu had been threatening to partially annex territory or whatever you want to call it. And these things came out. Now, some people were skeptical. They saw it as a kind of a deal Trump was doing to sell arms to the UAE. How do you read it? And do you think this is going to have a big change on the region? Is it going to change the way we look at international law? You're on mute, I think, Daniel.
And thank you for that. Right. First of all, it's such a pleasure to be with you. Thank you, Andrew. Thank you, Peter. Thank you, Sarah. Thanks to Elnet. I saw Pascaline, I think, on the call as well. So thanks to all the stuff that you're doing, not on the legal tracks, on the other tracks of what you're doing. And obviously, thanks so much to all the participants and the participating organizations for doing so much to do exactly what Daphné was talking about, which is to actually stand up for the integrity of international law and international and legal institutions, which is absolutely so critical. I so much enjoyed Daphné and Yael's thoughtful and far-reaching presentations. You've given us something of a challenge, Andrew. You said, we want to be more, towards the end of your course, we want to be more forward-looking, we want to be more optimistic. I have to say, international lawyers relating to Israel don't often get asked to be forward-looking and optimistic, and it's a little bit of a challenge for us. But I think we have a moment when we can begin to do it. But with your permission, I think in the context of this discussion, it might be helpful to provide a little bit of context and take a step back. And one of the questions that you asked in our correspondence that might be a good framing is the question of what is the role that international law and international lawyers can play in the context of peace negotiations and trying to resolve a conflict. And I think it's worth trying to track that because it gives us sort of interesting commentary on what is actually happening at that point in the attempt, the different models of trying to resolve a peace, a peace conflict, and what I would a conflict. And what I'd like to do really very briefly is just sketch out some thoughts about the different roles that international law and international lawyers have played at the various stages in the conflict, from, if you like, from Oslo to the Abraham Accords. And that will give us a number of sort of mental models, I think, if you like, that will be relevant. I hope that's okay, Andrew.
Sure.
So if we start with Oslo, I mean, I had the opportunity to be involved in some of those early rounds of negotiations between Israelis and Palestinians. It was genuinely an extraordinary experience walking into a negotiating room where on different sides of the table you had Israelis and Palestinians who had literally been on opposite sides of the barricades in the first Intifada. You had Israelis who spoke Arabic because their job had been to interrogate terrorist suspects, negotiating with Palestinians who spoke Hebrew because they'd spent extended periods of time in Israeli prisons. And together you're trying to find a new language to try and bridge the divide. And I think at that time, there was quite an important role played by the lawyers on both sides because they were the members of each delegation that had something of a common language and a common skill set. We were still at early stages in building our relationship. And the fact that we had people of similar, at least professional interests and language was important for bridge building. And not only that, in many ways, the negotiations were very, very legal. If you look down the contents page of a textbook on public international law, there are issues that almost never get discussed anywhere else in the world, but we were discussing them here. What is a state? What is self-determination? What is autonomy? All of those sorts of really critical conflicts who talks about the Montevideo criteria for statehood anywhere except in the negotiations between Israelis and Palestinians. So they were very, very legal. They also actually were very legalistic, in beyond being legal. I'll give just one example because it stays with me as a sort of model of maybe what's needed, the type of attitude. As I'm sure everybody knows on this call, at that stage, we were not negotiating the issue of Jerusalem. It's a permanent status issue. But here and there, the issue of Jerusalem did raise its head. And one of the places where it raised its head was in relation to the elections in East Jerusalem, where one of the questions that arose was, should there be polling stations for Palestinians in East Jerusalem? Which, it was clear that they had to participate in the elections, but did they actually have to have polling stations there, or should the polling stations be outside? So in the end, part of the compromise was that 4 post offices were selected in East Jerusalem, and elderly and infirm East Jerusalemites were invited to cast their votes there. The thinking being, with this sort of legal obfuscation, that Israel, the Palestinians could say this is voting in East Jerusalem, and Israel could say it's in a post office, it's not really happening in East Jerusalem, it's a postal ballot, it's happening somewhere else, we don't exactly know where. And that didn't end the debate, because believe it or not, there was a conflict between the Israeli side and the Palestinian side over what the boxes in these post offices should look like. And should the slit be in the side of the box like a post box, or should it be in the top of the box like a ballot box? And incredible as it may seem, we actually built special boxes that had a corner cut off at a 45-degree angle, so that one side could say it's at the top and the other could say it's at the side. And on the one hand, it seems sort of crazy that grown people are playing these sorts of mind games. And on the other hand, when you are going to close to the heart of the national identity of both sides, you know, sometimes you need this somewhat legalistic obfuscation to allow you to leave a little bit of room for the narrative of the other side. So there's a lot more to say about it, but I think in those early days, those hopeful days of the beginning of the Oslo process, the role of international lawyers was to be bridge builders between the two sides. And the model that we were involved in at the time of the Oslo process, as you know, was a model that was based on graduality. The idea was, let us postpone the tough deal breaker permanent status issues. And in the meantime, let us engage in a series of confidence building interim issues in relation to Gaza and Jericho and other areas, and then use the momentum of these agreements to try and overcome the permanent status issues. And the tragedy of that series of agreements that we reached during the 1990s was that rather than being a spiral upwards of confidence building, it was a spiral downwards of loss of confidence. And as that happened, the role of the lawyers in the negotiations changed. From having been bridge builders, we effectively became defense attorneys on each side, trying to explain why it was that our particular side hadn't implemented their obligations because this was a proportionate response to a failure or a breach on the other side, and so on. And if you think about it in terms of the dynamic of the negotiations, rather than looking at each other across the table, our heads turned outwards and were faced towards the international community, the international media, other institutions, the mediators, and so on and so forth. And that was that was an unfortunate dynamic. The negotiations were still continuing. And if you think about it, it's very hard to play both of those roles simultaneously, to be a constructive bridge builder and at the same time a strident defense attorney for your side. And one of the points that I used to make to the Palestinians at the time is they had a single team of what was called the Negotiation Support Unit that was tasked with doing both of those things, going to CNN and justifying Palestinian non-compliance, and then going back into the negotiating room to discuss with us across the table. And I remember saying to the Palestinians, maybe you need to do both of those things, but can you at least have two separate teams so that the person that is coming in to negotiate with us is not thinking, how am I going to justify non-compliance on the news channel this evening, and so on. So that was, in a sense, the second role that was played. And then we reached the end of the 1990s, and of course, Ehud-Barak tried to make a dramatic move to cut to the bottom line at Camp David. That offer was effectively rejected by the Palestinians, and more tragically, Yasser Arafat opened the door, gave a green light or at least an amber light to the outbreak of violence. And then, of course, the role of international lawyers changed again, very dramatically, because now our goal was to advise our governments and our military on what you can and can't do in an extraordinarily complicated set of circumstances. And they're very complicated legal questions here, particularly in new types of conflict, asymmetric conflict. What is the relevant body of law? Are we talking about a criminal paradigm? Are we talking about a law and order paradigm? Are we talking about Israeli law? Or are we talking about international law? And it's not so much, even if we are talking about IHL, it's not so much, and one of the things that frustrates Israeli international lawyers is when political leaders say, international law is useless, we need to change it all. Actually, international law as we have it at the moment is probably not bad. But what we do need to think about is how we apply existing principles, tested principles, in very new circumstances. And that can be very challenging when you have the sort of asymmetric conflict that we're in. What does direct participation in hostilities mean in these new circumstances and so on. So that was a new role, a very, very challenging role. Another aspect of it is, how do you get international law into the operational system? You know, you can try and take senior military personnel before a conflict and educate them. You can engage in investigations after issues have come up. But actually, during a conflict, what is the role of international lawyers? And, you know, it's one thing to sit in an office and think about potential targets, but what do you do in the heat of armed conflict? And one of the things that I remember that was so interesting was the dynamic there was almost counterintuitive. It was the international lawyers that were saying, you know, we want to take a step back here. The correct approach is to leave this to the reasonable military commander to decide what they should and shouldn't do. And it was actually the military commanders that were saying, no, we want the international lawyers to be with us almost on the battlefield, telling us what we can and can't do. So again, this was a very intense and quite dramatic change of role for international lawyers. And then, as is reflected in much of what we already heard from Daphné and Yael, the role of international lawyers changed once more. And that was when international law became not a guide in advising how you can use your weapons, but it actually became a weapon in itself. As we saw the international legal arena become a battlefield. And this, of course, is something that's happened over a long period of time. We've seen within the UN system an expansion of the circles of political influence from, you know, way back in the 1970s and 80s, Zionism is racism, the political organs of the UN, to the 90s, you know, what was then the Commission of Human Rights, which became the travesty of human rights protection that it remains today. And again, we've heard about this from you, Andrew, and from other speakers and so on. But then we saw this circle of political influence, leveraging the automatic majority, against Israel within the United Nations, impacting on all sorts of legal institutions, and alongside that, a deliberate concerted decision by the Palestinian leadership to adopt this as part of a strategy. And it's not denied, there was an extraordinary op-ed that was written by President Abbas in the New York Times, where he said that the reason he was aspiring to statehood was so that he could wage a campaign against Israel in international legal institutions. And it wasn't, I want to wage a campaign in order to achieve statehood. It was, I want to be a state so that I will have the standing and the jurisdiction in order to be able to perpetuate and expand my campaign against Israel. It was an extraordinary admission, unfortunately one that people didn't pick up on sufficiently. And that led to all sorts of sad consequences, not only for Israel, but for these institutions themselves. And, dealing with our conflict, it turns out, tends to be a poison chalice or a kiss of death for the integrity of many international institutions. Where we see the integrity of those institutions. The decisions that are passed in relation to Israel, as a general rule, and we can go into them, tend to be the ones that are less in accordance with the principles, with the guiding, statutes of those organizations and so on. And it's sad. It results often in a perversion of international law. I mean, Andrew, you talked about earlier the EU, for example, basing its decisions on international law. But frequently, it's a perversion of international law when it comes to our part of the conflict. I remember one statement of the EU presidency where they said that any activities, this was in relation to Israel's conflict in Gaza, any activities that endanger the lives of civilians are violations of international law. And that is a very profound misstatement of international law. If you adopt that as a principle, you are really issuing an open invitation to every terrorist organization to set up shop inside a school or a hospital or a kindergarten. So we really need to be on the guard against this. And this is why the point that you made, that Daphne made earlier, is so critical, that voices that preserve the achievements of international law on these issues need to be heard. So as we watch this happening, and I'm thinking about the role that is being played by international lawyers here, it creates extraordinary challenges for us. And at the root of these challenges is probably a single fundamental dilemma, which is, if we hear about an initiative in an international legal institution, do we participate? On the one hand, our instinct is to participate, to raise our voice, and to try and influence the outcome. On the other hand, if the odds are so stacked against us, our participation is going to give some kind of legitimacy to an initiative that really needs to be rejected wholeheartedly. How do we navigate here? And again, there's a lot to say about it, but just in very broad strokes, I would say, as a general rule, Israel's default position is to participate. And Israel participates in the vast majority of initiatives. We probably have more investigators, special rapporteurs, and so on visiting Israel than certainly per capita any other country in the world. But there are instances where the odds are stacked in such an obvious and distorted way that there is no benefit in participating. And you're thinking about some of the questions that we ask ourselves in trying to weigh that up. First of all, if an initiative is being used in relation to Israel, is it applied universally? If it's not applied universally, that's a pretty clear sign that that's not a human rights concern, that is a political concern. I think about the number of times the parties of the Geneva Convention have gathered under the auspices of the Red Cross to investigate situations of occupation and the application of the Fourth Geneva Convention. And I think it's happened 3 times in relation to Israel and never in relation to any other country, despite so many occupations and so on. The question that came up earlier, is it lawful in its own terms? And here again, there's something sort of ridiculous. You think about the basis of jurisdiction of the Palestinians in the ICC, and here we have the court deciding that they are enough of a state to give the ICC jurisdiction. But then if we look at the ICJ advisory opinion on the fence, they are not enough of a state for Israel to have the right of self-defense against missiles that are coming out from that territory. There's an absurd contradiction here. And the question is, do we, in the interest of participation, just sort of roll over? There are other questions we think about, whether the body concerned has the relevant expertise. You look at what counts as military expertise on some of these investigative inquiries, and it's really no familiarity with actually the challenges that and Israel is a double victim here, I have to say. It's not just that we're on the receiving end of politics, but we could really benefit from having an informed discussion on some of these issues. It's just that the bodies that are being established aren't capable of having that kind of informed discussion, of actually thinking what it means to implement their principles in practice. So
do the Abraham Accords
I don't talk about the Abraham Accords now.
Do they create that? Do they create some space for that discussion?
So the answer is, I think they do a lot of things, but probably not create the space for that discussion. And let's talk about what they do and what they don't do. And it may be that we don't want them to do it either. I think we need to think long and hard about what it is that we want these Abraham Accords to achieve. I think the first thing in the context of this broad survey is what we've seen is sort of a sad decline from that aspiration that the lawyers had at the very beginning of how they were going to be bridge builders. And I think what the Abraham Accords have done is resuscitated that. They've given us a sense of hope about what agreements between states, what between different parties can be like. And I think here at root, in negotiation theory, there is a very simple distinction that sometimes we forget to make between a dispute and a deal. Now, the word deal is become a little bit dirty since it was used by the previous president of the United States. But here I'm talking about, a dispute is a situation where you are locked in a conflict with a single party and you have no other alternatives available. And if you don't reach an agreement, you're still stuck down there at the bottom of a pit. Our agreements with these countries under the framework of the Abraham Accords are far more deals than they are disputes. These are genuinely forward-looking. What motivates them is the possibility of creating joint opportunities. I'm sure people know, but just to clarify, the word Abraham, the term Abraham Accords was originally used to describe a very specific agreement, a trilateral agreement between Israel, the UAE, and Bahrain. It's now become a sort of much broader term of art that describes agreements that also include agreements with Sudan, with Morocco, and under those, an entire range of implementing agreements. Like Daphné, I was just in the UAE the other day. We didn't bump into each other, but I was also in the Palestinian, pavilion in the expo and the Israeli one. But just thinking about that visit, and you think about the flights and the visas and the COVID arrangements and the currency arrangements, and that's even before you get onto the trade cooperation and everything else that is happening. And all of this is opportunities, deals that have been made possible by the work of lawyers putting together an extraordinary set of agreements. And it's sort of moving to realize how lawyers can be architects of the scaffolding that actually build these things together. And one of the things that's so striking about these agreements, they are so positive and forward-looking. I mean, some of our previous agreements talk about things like interfaith dialogue and people-to-people cooperation. But in these agreements, they really mean it. There is something about the spirit of that agreement that is really there. And what's also interesting is what is not there. And with hardly any exceptions, the Palestinian issue is not there, and so on. And I have to say, I know somebody mentioned earlier that it might, I have to say, I don't detect any particular interest on the part of the other parties of these conversations, of these agreements, to become embroiled in those issues. I think the major contribution that they can make is to rekindle an image of hope and opportunity and prosperity. And I certainly don't think it would be helpful for them to become embroiled. And I know I'm coming to the end of my time, so I'll just finish maybe just with one thought, trying to connect maybe these agreements together with the history of some of our other agreements and go back. These are very different agreements to the agreements that we signed with Jordan and Egypt, which have some of the same language, but were certainly far more in the dispute category than they are in the deal category. But there's something that I do draw hope from in relation to our earlier peace agreements, the ones with Egypt and with Jordan. And that is the degree to which those agreements have weathered extraordinary storms in the Middle East. They have been through the Arab Spring. If you think about it, particularly in relation to Egypt, people didn't even think that an agreement with Sadat would survive to last a Mubarak. And it survived a transition to the Muslim Brotherhood and then out of the Muslim Brotherhood and so on. And the thought that I would like to take away from this, and I think actually does give me some deep hope, is that it may well be that it is harder to reach peace agreements than we would like. But once we have achieved them, it seems, certainly the record seems to show that it's harder to break them than you might think. And so there is something about the role of lawyers as architects building these scaffoldings. And as tough as the job is, once we get the job done, hopefully that will be something significant that will be with us and the region to stay.
Thank you, Daniel. Super. Well, it's been amazing. Each of you, you've brought such an amazing amount of information and wisdom and understanding to the table. A lot of food for thought. I'm terribly afraid that we are breaching international law here severely because we're going well over time. We promised people we would close at 5:30, and it is 5:30. So we really don't have time for any questions and answers. I'm going to look to you, Sarah, to see if there's anything urgent that we could deal with, but I don't want to go longer than we said we would. And I don't see any other questions in the chat of a legal nature that need to be dealt with.
There is one question about the Oslo Accords. Could the Oslo Accords be described as transitional justice?
Yes,
Thank you.
perfect. From Hugh Kitson. I saw that question, hoping that I could jump in. Thank you, Hugh, for this question, because it was exactly the conclusion I didn't reach yet. In order for the Oslo Accords or any future peace agreement between Israel and Palestine to deal with transitional justice, it will have to have a chapter on justice, a justice chapter, in the same way as the Colombia example. So Colombia has a special jurisdiction for peace, and I will stop there.
Okay. Thank you. Well, we're going to take all of this away. I think we've given ourselves a food for the next course. So keep your eye on this page, and we will no doubt be following up with a new course going deeper into many of these issues. I want to thank our speakers of today, Daphné, Yael, and Daniel, for the time that you've taken for sharing with us. It's been absolutely amazing. And to all our participants, this is the end of our 5-part series course on Israel on Trial. I hope you've enjoyed it. Thank you for your participation, and we look forward to seeing you in the next course. So I'm going to hand back to you, Aryeh.
No, I don't have anything to add to what you said and to what our speakers said today. It was very interesting, very deep, and we have a lot during the coming days and weeks to think about everything we heard and we learned from all the speakers that we have during this 5 session. Just I would like to tell you that we are so happy about this cooperation. We think that we at ELNet decided to come back next year with another seminar, not on 5 sessions, but on more, because we think that it's very important to continue to build the knowledge of our volunteers and leaders. So if you appreciate this Israel on Trial, we will be very happy to meet you again next year.
Thank you so much.
Thank you, ELNet.
Happy New Year. Merry Christmas to everybody.
Happy New Year, Merry Christmas, and God bless you all. Thank you so much.